Okay, yeah, good evening, Shukru. Everyone, thank you once again. It seems it's like a one-on-one session today because you were the only one here. But let's see how far and how fast we can go. Please do well to call me back if do well to call my attention back to anything if you cannot hear me, or peradventure if you have a question, you can please draw my attention to it, and I would gladly go back and explain as much as I can, because the goal is for you to understand as much as you can. Particularly, I think because this topic is a bit tricky, it is winding up proceedings, winding up and dissolution of company, right? So please feel free to call my attention to it. And I think I understand that I don't think you have been taught this topic, but it's like one of the last few topics in law school, so it might be that it's on its own, by the way. So yeah, let's just dive into it. Winding up and dissolution of company. Might not be able to grasp as much, but what I would say is that just try to catch what you can, and maybe whenever you're reading your topic or when they're teaching in law school, you'll be able to maybe have a fuller understanding. But what I would do is I'll just lay a foundation to the topic as to most important things, or things that I feel are very important that you need to note for the purposes of bar finals. And one of those major things is to differentiate between winding up and dissolution. And I'm saying that differentiate is not like there's a major difference, but I'm saying that because of MCQ. I think I remember I came across a question like that when I was in law school regarding something relating to winding up and dissolution, and what is dissolution and what is winding up. It basically, on the surface, it basically seems like they're the same, but one major thing that you should know is that winding up is more or less like the procedure to bring a company to an end. So in typical understanding, or in the same context, or using the same word of winding up and dissolution in the same sentence, you can say that winding up is the process that leads to dissolution, because dissolution is the death of a company, right? So let's say winding up is the process that leads to the death, is the cause of the death. So when you hear that a company is dissolved, meaning that the company is dead, a company that is being wound up does not necessarily mean the company might be dissolved, right? And I'm using this as an example. There's so many companies, some companies that have been revived in winding up process, whereby the liquidator did so well to bring back the company, or in the process, some of the directors, willingly opted to take over the liabilities of the company, and in that process were able to revive the company. So therefore, the company did not eventually die. So practically, winding up is the process of bringing the company to an end, right? And there are many ways in which you can bring a company to an end, really, right? But not total dissolution. So dissolution is the end, like you cannot come back again, right? Say striking off. Striking off is a way of taking out the company out of the life process. But there are ways whereby a company that has been struck off can be relisted when you follow the process with the CAC. Do you get? So that's one thing. And I think one major important thing that you need to know is the point. At what point will you say winding up has begun, right? And this is important because you can see it in bar finals, you can see it in MCQ or at any point in time. But one thing that you really need to note is that when do you say a company has been wound up, and when do you say a company has been dissolved, and which is what I've explained earlier. Particularly, the point at which I'm trying to make now is that point of, at what point do you say that a company, the winding up proceeding has started? which is that point at which, in two instances, if it is a voluntary winding up, which we'll get there, a winding up, it is assumed that. Can you hear me, please?
Yes, I can.
Okay. For winding up proceeding, where it is a winding up by a voluntary winding up, it is the law. The procedure is that the winding up has started the moment the moment the resolution is being passed by the members, right? The moment there's a resolution that's been passed to say that yes, we've agreed, we the members of this social company so hereby agree that this company should be voluntarily wound up and this social liquidator be appointed, or a liquidator should be appointed. That is when it is being said that what winding up has started. And if it is winding up under by the court or under the supervision of the court, it is winding up. It will be said that winding up has started the moment a winding up petition has been filed at the Federal High Court. So in case you see bar finals and you see a scenario and they tell you that, oh, at what point has winding up commenced? I think I've seen it one of those years, I can't remember. And so you know when do you say it has started. When it is voluntary winding up, it means that it's winding up proceeding has started the moment the resolution is being passed. Even if it is supervision of the court, because if it's winding up supervision by the court, it means that the resolution has to be passed for you to say that, oh, you want it to be, you want the court to wind up under this, you want the winding up to be done under the supervision of the court as opposed to voluntary. So at that moment the resolution is being passed, that is when you say that winding up has started. But if it's by petition of the court or winding up by the court, the moment the petition is being filed, that is when you say that winding up has started. Right. And winding up only applies to incorporated companies. Right. Winding up only applies to incorporated companies, as business names and incorporated trustees are to be dissolved straight up. There's no winding up process. There's no winding up proceeding in between. So yeah, just to move ahead because of time, I think this class is to end by 6:15 thereabouts. So let's see how far we can go. There are 3 modes of winding up. We have compulsory winding up by the courts. We have voluntary winding up by the members or creditors, and we have winding up subject to the supervision of the courts. Yes, so our wonderful senior has blessed us with additional time. Thank you very much. So yeah, if you say compulsory winding up by the courts, it is winding up by the courts just basically known as what is known as the compulsory winding up, and the courts with jurisdiction is the Federal High Court. I'm sure if you remember your civil litigation with court of jurisdictions or jurisdiction under civil litigation, whereby we were taught about jurisdiction and what falls under jurisdiction. You remember that the issue of companies and the way everything under karma is being treated under Federal High Court. So it means that winding up is basically done under the supervision of the Federal High Court. Now, however, the important thing to note is that you remember what they call, I think it's not forum shopping. It's not forum shopping, whereby the court has held that typically when it comes to a court with jurisdiction, I think even in dissolution of marriage, you would know, and some other procedure, they say that the law is you can have a proceeding anywhere, but then the one that is closest to the proximity of the issue is what you should look at. I think it's forum shopping. I've forgotten the term, whereby you cannot the both parties.
Yes, forum shopping.
Yes. So
under criminal.
Okay. Yeah. Thank you very much. So you have to do within the jurisdiction. So you can't say that because it's Federal High Court is just one jurisdiction, right? And say that everything is happening in Lagos, and you just say, I don't want to do it in Lagos. You decide to go and do it in Aba, or you go and do it in Port Harcourt, or you go and do it in Katsina, right? And I think same thing happened. I think in matrimonial causes when it comes to dissolution of marriage, whereby the courts you can have your dissolution anywhere, but the court has also held that for the purpose of convenience, you have to do it because people do it because of them. Some parties do it because of them being malicious. They know that the other party might not be able to afford lawyers who will be able to go down to that particular state or hire people within that particular state, or for them to travel down within that particular state. So the law has made it that it has to be within. So where the company has a place of business which has been the principal place of business at least 6 months, to the presentation of the winding up petition, then that office will suffice at the head office. So it therefore means that what the winding up proceeding has to be, the court will be within that area. So Lagos, even if the headquarters has been in Abuja for a longest period of time, so for 6 months to that winding up, Lagos has been assumed to be the headquarters. That is where it will start. And there are instances whereby the court has to be the one. There are instances whereby winding up by the court is being done, and one of the major instances is where there's a special resolution that has been passed, right, to that effect. That is, the company can by special resolution resolve that the company has to be wound up by the court. Now, this issue is probably going to come up when we are dealing with winding up proceeding under the supervision of the court, because they are similar. Both of them, resolution has to be passed, but what is the difference? The law is just that when there's a special resolution passed by members of the court to say that yes, we want the court to voluntarily wind up this company, or we want the court to wind up this company by the court, then that can be an instance. Another instance is where the company is unable to pay its debt. Now, where the court is unable to pay its debts, whether the amount is contentious or not, the petition, where the amount is owed, when the amount owed is contentious, then the court might refuse it. But one very important thing to note is that you have to, where the company is able to pay its debt. So before the BFA, the Kama pegged it at, I think, 200,000 naira, where the company is unable to pay his debt of 200,000 naira upward for a period of some certain months, then it will be there. But BFA has amended it and deleted that term 200,000 naira and has now made it open. So what then determines the amount is then open to the interpretation of the court, right? And I think that's one thing that I don't fancy by it, because I actually believe that so please hold and give me like a minute. Sorry, apologies. I got to quickly attend to something. Yeah, so as I was saying earlier, I was speaking as to instances whereby the court as to where compulsory winding up is done by the court is that point of where the company is unable to pay is there. I think I mentioned earlier that before the amendment, before BFA in 2022, Kama has a pegged amount. I think it was 200,000 naira, where the company cannot pay its debt of 200,000 naira above within the period of, I think, 2 months thereabouts. Then they can petition for winding up by the court. However, what BFA has now done is to delete that monetary requirement of 200,000 naira and has now made it open, right? It has now made it open. So there's no specific amount. Everything is now dependent on the interpretation of the court. Other one is where the number of members is below the legal minimum. We all know that Kama has now provided that as much as you can have a single shareholder company, there are some companies that they cannot have below they cannot have below 2, right? Particularly, I think it's only private companies that can have 1. So where some of them still has the legal requirement of not having less than 2 members. Once it's less than that, the court can wind up the company. Also, where there's a condition precedent based on the operations of the company has ceased to exist, the company is no more effective, nothing is happening again, everything is out of it, the court can wind it up. And when there's a default in delivering the statutory reports and holding statutory meeting, there's this provision that says that when there has to be a statutory report that must be done, and also there must be statutory meeting that has to be held by members of the company, and only shareholders can bring a petition within 14 days. So when all this thing has failed, like a statutory declaration, statutory reports, when you're meant to hold the statutory meetings within the period of time and nothing is being done and it's just left in holo, court can wind it up. And when the court feels that it is just an equitable ground, right, in the opinion of the court, that it is just an equitable for the company to be wound up, say for instance, fraudulent purposes, money laundering, and the court feels like, this company is basically just it's an affront for money laundering and every other thing, in his opinion, the court can voluntarily wind up the company and close it down. right, the courts can close it down. So also please that point of, I think is section 572 of comma, right, where it has been defined that where the court is unable to is deemed unable to pay its debt. And I think I said that it has moved away from to when the court is owing the sum exceeding 200,000 naira, but I know that monetary sum has now been taken out by BFA, right? So please do it to cross check. Do it to cross check the section. I think it's section 572. Basically, it's like everything of valued up start from 5. I think from 5 something down to 6 something. So everything on winding up follows suit in that order. Right, and also, so when you want to then commence winding up, right, by order of the courts, how do you apply? Because like I said, that it's by way of petition. You petition that, so whoever is, whether it's the director or is the member or is the credit member that is trying to wind up, will be the petitioner, and will be the petitioner, and the company itself will be the respondent. And it means that what the company or a director can be the one to file the petition, and if it's a creditor, right, when there's sufficient security for cost has been established to his satisfaction, then there must be an official receiver. If the company is voluntarily wound up, it means at the point of petition, letting the court know that we are petitioning for this person, for this company to be wound up, and also notifying that this particular person should be appointed as a liquidator. Most case scenarios in practice nowadays, when the same board meeting, the same member, the same meeting, whereby wherein the resolution is being passed for the winding up of the company voluntarily, most times they also pass a resolution for the appointment of the liquidator as well, because typically once you petition, you do it, you appoint the liquidator thereafter, and so that the process can begin. And like I said earlier, when a resolution is being passed for voluntary winding up, then the winding up is deemed to have commenced. However, when it is by court, it has to be at the point of what? Petition. Right. And one very good effect, some of the effects that you can think of when you commence winding up by the courts is that every asset of the company or everything that the company might have, whether you're trying to transfer your asset or whether it is shares or whether it is even if you want to outright anything that has to be the members, shall be void unless the court orders otherwise. Meaning that the moment you commence winding up of the company, you cannot deal with the company again. The company cannot deal with it by itself unless otherwise by the court. I think this is not a compromise. There's particular one that when it commences, the companies can still due, right? Now, so one major difference is this, whereby it is the courts that's been wound up. It means that every decision that's meant to be done by the company is going to be done by the court, right? Until the court appoint a liquidator. Same if voluntarily it is the liquidator that can now do anything. So it means that the director typically loses their powers as alter egos of the company, right? Because the company is in the process of winding up. You cannot do anything as such. So what happens is the court takes over. If the court appoints a liquidator, or if the company has appointed a liquidator, that is the person that then begins to take charge that is now in the aims of affairs. That person will not be seen as the alter ego. So the director basically, quote and unquote, lack power to do anything that binds the company. Right. Another thing about commencement is just like when people declare bankruptcy. When you declare that you are bankrupt, it means that nobody can come for you. Nobody can sue you for garnishing proceeding. Nobody can go with you for recovery of debt, because you're basically declaring that you don't have anything in your name. So same thing for winding up. Any other of sequestration or execution that they want to levy against the company is void, because it's deemed that the company has nothing again. right? So both the company is project of winding up. Everything that has to do with companies, the settlement of its debts with whatever it has, and it folds. So now, I think I forgot to mention that when you are dealing with winding up, as much as you are dealing with karma, you're also dealing with the winding up, with the company rules, you're dealing with the company's regulation, and also dealing with the company winding up rules, right? There's a rule for winding up that's, I think it's 2021. One is, I know one of them is 2021. I think that's company's regulation. Company winding up rules is, I think, far back as 19 something. That one is so old, but that's what is in effect. So you have to also pay attention to it. So what are the procedures for compulsory winding up? And very important, I think I've mentioned it before, unlike civil litigation, property, where you have to do more of draftings for your corporate, you really need to know your procedures. Where civil is taking so many drafts, corporate is taking up so many procedures, and it's something that you must know, right? I think I remember in law school then there was a particular recording. I don't know the person. I think the person went into studio, but the person converted into a song, and that was what I listened to that make me remember the procedures of compulsory winding up, or winding up in general. The person had the song to make it easy. So please, you really need to pay attention to your procedures. The procedures for compulsory winding up, after the special resolution that the company should wind it up, that is where it is in that way. You file a petition alongside a verifying affidavit. You serve the petition. You do advertisements, because part of your petition and part of your affidavit is that you want to wind up, and the court also grants you permission to also advertise the petition. The moment the court grants it, then you send notice of the petition to the creditors to know that and that's one thing that the advertisement does. If the company is owing anybody, everybody come forward. We are winding up. Come and collect your money. Come and state your day. Let us pay for our money. Then there's a filing of memorandums of compliance. Then notice of intention to appear. Then where there's a need to be applied, the petitioner applies. Then the appointment of liquidator. Once you appoint liquidator, they make the winding up orders, and then everything begins to work. When winding up is done and liquidation is done, the debts, the creditors has been settled, the debtors, that is the creditors, has been settled, then the share members has been settled. Then what happens is they serve the winding up order and they apply for dissolution. And once everything is complete, the company has been dissolved and struck off. And once that's been done, you file a copy of the dissolution order at CAC within 14 days. Yeah, and that's practically maybe something I need. Right, then for voluntary winding up, I know that I've spoken about voluntary winding up in between our conversations of compulsory winding up. Like I've said, voluntary winding up is sometimes books categorize into two. Well, just know that only two sections. A company can voluntarily winding up by two type of people, and as we know, for every company, we have the members and we have the creditors. Members are, let's say, shareholders, people that own a part of the company, while creditors are those that the company owe money to. So it means that those are like the two people that are keeping the company afloat. One is those that are that have equity, and one is those that have debt. A company survives on both equity and debt, right? Those are the two people, right? And those are the only two sections of people that can bring up that can commence voluntary winding up. That is that where the shareholders, that is where the members decide to voluntarily wind up the company, or where the creditors, where they has not been met with any, and they decide, you know what, at this point, let's round it up, let's sell everything that we have, let's get our money back, and let's fold up. Or the members can say, this company does not bring any profit, it's just like we are expanding so much and there's nothing. You know what, let's round up the company, let's get our money back, and let everybody disappear, right? So there are some textbooks would design and tell you that there is members as part of, earlier I mentioned that there are just three, which is by courts, voluntarily, and by supervision of the court. Some will divide that voluntary into other two and make it look like it's 5 or 4. So for voluntary, there's the members voluntary winding up and there's the creditors voluntary winding up. The major instance you just notice that one, the resolution is being passed by the members, one, the resolution is being passed by the creditors. And one thing is that where the members are the one voluntary winding up, there must be a director's statutory declaration of solvency to say that we are solvent. We just don't want, again, we are solvent, we have the capacity to pay back everybody's debt and let everybody take their money and disappear. Right? And a company in this regard may be wound up by maybe an ordinary resolution when the period fixed for duration of the company by its articles expires. That is some companies end whereby, when we talk about fixed tenancy in property, in civil litigation, we talk about fixed tenancy whereby we know that some people, their tenancy expires, and when it expires, that's the end. There are some companies that, and I'm sure they might have probably spoken about this when you're doing your arrangement and compromise, and or when you're doing restructuring. So companies that when they're almost done, what do? They do arrangement. Is it, I think, not arrangement and compromise, something on sale, right? They decide to sell the asset of the company, create a new one, transfer the asset to that one, and look like they're starting up a new company. So there's that instance whereby many companies have that, term in their articles of association to say that, we want to be able to trade up to this amount. Say for companies in finance, say you want to be able to trade this amount and achieve this social money within a particular period of time. The company will be dissolved when that has been done. Or say that we want this company to survive for 10 years. Anything after 10 years, the company is going to the moment that mark is being done, it's going to be another resolution and say, well, by virtue of the article of association of the company is meant to terminate at this point and this point. The duration of this company has come to an end, and so therefore the winding up is coming based on contingent of what has been proposed in the articles of the company, or whereby there's a special resolution where the company has resolved that either the members now or the creditors have resolved that we want this company to be wound up. One major difference between members voluntary winding up and creditors voluntary winding up is when it's members voluntary winding up, there is a declaration of solvency, statutory solvency, to state that we have the capacity to repay the debt, and that's why we just want to wind up the company. Right. So really, every member's voluntary winding up is only possible when there's a statutory declaration of solvency. Where it is creditors, there's no statutory declaration of solvency because you are stating that the company is in debt. That is why you're winding up. But for members voluntary winding, you are saying that we have the money, we the directors have the money, and we just want to make sure that we have full inquiry into the full affairs of the company, and your opinion within 12 months from the process of this winding up will be able to pay up all his debt in full and will be good. And that's it. And it must be made 5 weeks before the date of passing of that resolution. So the statutory declaration must be dated 5 weeks before the special resolution, the passing of the special resolution for winding up the company. And the statutory declaration must also state, it must be the company's assets and liabilities and the latest, predictable date, to say that yes, we are solvent, this is what our assets, this is what our liabilities are, this is how much we have, and we are so certain that within 12 months from the commencement of this day, that is within a year, we are able to pay off any outstanding debt, clear off any liabilities, and will be good, and therefore want this company to be wound up. Right. And furthermore, it's also important to know that where the company if a company is being wound up, that declaration is made and they are unable to pay their debt within that 12 months or whatever time that is being stated, it is presumed that the directors does not have any founded opinion of whatever they've said. Therefore, they'll be liable to an offense, because it's like perjury. You are making a declaration that we have the money and we'll be able to pay within 12 months. If you don't do that within 12 months and there's no reasonable decision or there's no reasonable reason why you're unable to pay, and it's just bare like that, it's like you've committed an offense. and but there's a conviction for it, and I think an imprisonment of up to 3 months and a fine or thereabout, right? And there's also procedure for the members voluntary winding up, which basically starts from what that declaration of solvency, right? From that declaration of solvency, it moves to the notice of the general meeting, to the special resolution, to the general meeting for the passing, to the appointment of liquidation, appointment of a liquidator. The notice of appointment has to be filed with CAC, and every other thing must be complied with. Please and please, I will say it over and over again. For winding up and every other thing is pretty straightforward. What might be tricky is the procedures, which please pay attention to. Then the creditors winding up is also the same thing. The only major difference is that what for creditors winding up, the directors are not making any statutory declaration of solvency. The statutory declaration of solvency is only made when the company is being wound up by members, but where it is by creditors, please and please, there is no statutory declaration of solvency. That is the major difference between members voluntary winding up and creditors voluntary winding up, and the meeting of attendance by the creditor, right? Attendance of meeting of creditors by the directors, which is not. I just know for this one, it means that what the resolution is going to be passed at the creditors meeting. For members, it's going to be at the general meeting where they're passing it. But for creditors, it's going to be at the creditors meeting. If you remember, under when you did meetings and quorums as a separate topic, under types of meeting, we have the creditors meeting, we have the extraordinary generals meeting, we have the and all those type of meetings in between. So the creditors meeting is where a winding up procedure, anyone that's been approved at the general meeting means that what is going to be a member's voluntary winding up, not by creditors. Right. Then one thing that you should always note here, I don't know, before I go on, Tijani, have you heard me so far? Like Shukro, rather, sorry for calling Tijani. Shukro, any questions so far? Any confusion?
Yes, I can hear you.
And is it straightforward so far? No questions, and is it clear enough? Okay then. Yeah. So some of the consequences when you voluntarily wind up the company is that the company ceases to carry on its business, except as it's so concerned with the winding up itself. Right? And it's the same thing under courts. That is, you cannot transfer shares. You cannot do anything except, under court, everything has to be approved by the court. But here, it has to be approved by the liquidator that has been so approved, right? And the moment you appoint a liquidator, all the powers of the director cease, except so far as the company in general meeting or whatever the liquidator assigns in its own name. That is what makes sense, right? Say for instance, a company is in the process of being wound up and wants to transfer its property. It means that the deed of assignment is not going to read the name of the company. To be that the company, to be like the reciter will read something as by the special whatever meeting that was being held in appointing the liquidator. One is the meeting for appointing to be wound up, followed by the appointment of the liquidator, followed by instructing the liquidator to assign or deal with the property. Then that would then be that it is now the liquidator on behalf of the company that will be the one to transfer the assets. So it means that if whoever is executing it has to be the liquidator, because in that point it's deemed that the director doesn't exist, is the liquidator that is the director of the company. So something similar like that. Do you get? Now, just to add, the last point is winding up subject to the supervision of the court. This is one that I said. It took me a long time, even in law school, to look at it and say that, okay, what's the difference between voluntary winding up and what's the difference between winding up by the court? And what's also the difference between winding up under the supervision of the court? Now, this one is winding up subject to the supervision of the court. If there's one that is voluntary winding up, compulsory winding up by the court. But one major thing to note for this is that it is a mode of voluntary winding up. However, the members subject it to the supervision of the court, saying that, oh, yes, we agree and we want to wind up this company, but we don't want to do it alone as a board. We want to do it with the supervision of the court. So in that way, there is a resolution saying that yes, so we want to wind up this company, and we are saying that it's going to be wound up by the courts. So rather than in a voluntary winding up, and when you just pass your resolution, you proceed to your whatever processes. Once you pass your resolution, you then still go over and then file a petition again. So in this instance, your petition will be stating that we are the one that voluntarily want to wind up this company under the supervision of the court. So subsequently, a petition has to be brought to the court that the winding up that we so want as members of the company, we want it to be done subject to the supervision of the court. Then the court can then order that, the voluntary winding up should be ordered to be done subject to the subject to supervision of the court after being applied by either the creditors, the members, contributors, or whoever is entitled for what compulsory winding up by the court. Do you get? And if the members have approved a liquidator before, whatever they have, the court can then begin to take over and say, okay, no, we want this liquidator, we want that liquidator, and begins to take over. And I think that's the major difference, right? Now, one other important thing to notice, I know you've heard me mention liquidator most times, and I think I mentioned maybe receiver once, but they are like separate people who or many or different terminologies with different concern, right, that is being owned. So one is, we have the provisional liquidator, we have the liquidator, we have the official receiver, we have the receiver manager. And so we just know that for a provisional liquidator is someone who plays the role of a liquidator until the main liquidator is being appointed. And the moment a liquidator has been appointed, it ceases to be a liquidator. That's why it's called provisional liquidator. Then we have the liquidator itself. This is someone that has been appointed by the company or by the court to wind up the affairs of the company and to distribute the assets. Right? What they are doing is, the purpose of a liquidator is to close down the company, not to revive it. That is one major difference between a liquidator and a receiver manager, if I'm correct. I'll be so sure to check on going forward. Is that point of one can revive and one cannot revive. A liquidator, the purpose of liquidator is, the company is closing, I'm taking over the company, I'm selling your assets, settling your debts, clearing any court case, making everybody go on, and let everybody let the company. His interest is to do what? To all the creditors. Like, the major concern of the liquidator is not the company. The major concern is all these creditors. How are they going to get their money back? And that's all, right? Which is why some people are not competent enough and cannot act as liquidator. Say an infant, anybody the court has found to be of unsound mind, a body corporate, an undischarged bankrupt. That's why most times liquidators are individuals and not companies, because a body corporate cannot be a liquidator. Right? Any director of a company under liquidation cannot come back and say, I want to be a liquidator. And anybody that's been convicted once for fraud cannot be a liquidator. And some of the major functions of a liquidator is, if a person other than the official receiver shall give the official receiver such information and access to the facility, like inspecting of books, documents of the company, that's what the liquidators for them, because they are not concerned about the company anymore. They're just concerned about how do we get money and pay back these people. And the court can direct an application of liquidator under winding up that all properties of the company to be vested in the liquidator by his official name. Like the example that I gave earlier about a landed property that can be handed over by a liquidator to an individual. And some of the powers of a liquidator is, liquidator in winding up, they have the power to sanction either of the courts or the committee to inspect, right? To say that, okay, I think I want the court to come and inspect maybe the books. They can bring an action on behalf of the company. so exists. They can carry on business if they think like it's beneficial to winding up of the company, because what they can then do is, okay, we need to pay up debts. We don't have enough. Even if we decide to sell the asset, it won't still be enough. Let us see if we can generate some more money that will be used to settle up the debts. Right?
Thanks for saving my plastic
They can
wall.
pay. They can pay any class of creditor in full. They can make any compromise or arrangements with the creditors. Also, a liquidator in winding up, they have power to sell the company. They have the power to appoint an agent because they are seen as the directors. They are therefore seen. They are therefore seen as what directors of the company, right? And liquidators being paid. They are being paid though. I know, and trust me, they pay them well. I know someone that charges in dollars. They want the person to be a liquidator because sometimes liquidation takes time. There are times that liquidation of a company can go on for more than a year. I know of a company that their liquidation proceeding has been on for like 4 years now, because they're trying to close. They have so many branches. They're trying to close one. They have some court cases available that they're trying to, settle. They have some places. They have the warehouse where they're keeping their materials that they still have to, pay the securities that are looking over those places until the court proceeding is done. So liquidation really sometimes takes a long of time, right? It takes so much time. Now we have the official receiver. The official receiver is always the deputy chief registrar of the Federal High Court, or any other person that the chief just so designates to say that, okay, I want you to be the official receiver for this company, and when there's a vacancy, and the person can be appointed as a provisional liquidator, right? So the duty of the receiver is to receive statement of affairs of the company, collect information about the company, and submit preliminary reports on each of the dates as possible after the date of the winding up order, when the winding up order has been made. Then we have receiver manager. Now, a receiver manager has dual duty, as is both to act in the interest of the company and of the creditor. When I mentioned earlier about liquidators' interest is just the interest of the creditors. But for the receiver manager, more of both of the company and both of the creditor. Like a receiver manager is not only concerned with trying to realize, like trying to just sell off assets, trying to settle whatever like the liquidator, their own is to sell assets, make money back, settle everybody's debt and go on. But a receiver manager can try to see if they can maybe bring the company back to life. They can take over the affairs of the company and try to stabilize and make profits, pay off creditors, do every other thing. And in the process, they can somehow even revive the company, because let's say a company that has good potential, maybe it was due to mismanagement. A receiver manager can do that, come back, able to boost the company back, and then hand it over back to the members. It's very possible. Then a receiver is appointed by a secured creditor, right? A receiver does not need to get involved with the management. The only receiver is just to realize the asset and pay off that of the creditor, just like the liquidator. But the one is not even concerned with the many other things. The receiver is just one. But a receiver manager, so we have an official receiver, we have a receiver, and we have a receiver manager. Right. And we have the committee of inspection. The committee of inspection is appointed by the creditor to assist in the voluntary winding up process. Yes, I think I mentioned earlier that we have some regulations. I mentioned the company proceeding rules. We have the company winding up rules. I think company proceeding rules is the old one. The winding up rules is the 2021. Then we have the Federal High Court rules. Companies regulation is also there. Please also always refer back to it, right? So another important thing is, what is the order of priority of which liabilities have been settled? Like in what order, as the company is receiving money, or as the liquidator is getting money, as the receiver manager has been able to bring it back, or asset has been sold. What did they settle? Who are those that they settle first? The first person that they settle all costs, including the remuneration of the liquidator. The liquidator first of all remove their money, followed by what? Any outstanding local rates and charges due from the company and payable within 12 months. Next, before the date of the winding up order is commencement, meaning that what? Every outstanding local rate, every charges that has been due to the company will be paid. Then you then pay what? All necessary taxes. You want to pay the pension, all the necessary tax deductions, income tax, everything from the company that is not exceeding 1 year before the winding up of the company, or winding up 1 year before the commencement start. You pay it off. Then you then pay salaries of junior staffs or servants of the company. Then you then settle the claims of creditors, secured creditors first with floating charge, before you then go back to what? Unsecured creditors, meaning that you pay secured creditors first, then afterwards you then pay the unsecured creditors. Then you then settle preferential shareholders. Then when the preferential shareholders get their share, that's when you then call on ordinary shareholders to come, and then they share the remaining. Ordinary shareholders are the one that take the least. So fun fact is just like when you deal with shares and they talk about dividends, sometimes ordinary shares can be the ones to suffer the most, and sometimes they can be the one to enjoy the most, because every other one is kind of fixed, say, for ordinary shares. So you want to pay the cost, you want to pay any outstanding charges, you want to pay every taxes, you want to pay salaries out, and you've now the debt has there's a figure for debt, you pay it. There's a figure for all the shares, you pay it. What is left is what? It will be shared. So if there's even more than enough, then they share all the rest within the ordinary shareholders.
Everything seems to move incredibly slowly, but here's where things get weird. When Chuck climbed onto the slingshot, Terrence let go before he was ready. Chuck wasn't prepared at all.
Right.
He smashed through wall after wall before crashing.
And it's important that a company in liquidation still has its legal personality, only that it is legally sick. While a company has been dissolved, does no longer exist. When I said at the beginning that dissolution is the death of the company, while winding up proceeding is the process that leads to the death. Right. And another thing is business names. Right. Dissolution of business names, it can be resolved by a court order, resolution by the partners of the business name, or death of the sole proprietor. When the person has the company dies, that's the end. But when you don't want to, when it comes to come by a court order, where the company or sole proprietor that is registered, when they cease to carry on business, the officer of the company or the partner or any person in interest or any personal representative will deliver to the registrar of the business within 3 months after business can say, we've not been carrying on business for the last 3 months, and so therefore we wish that the company be removed. And once that is being done, once they receive the letter, the company or when the registrar receives that, he removes the firm or the company or the business name from the register. Where the registrar of the business has reasonable cause to believe that the company is not carrying on business, he will send notice first and say, are you people carrying on business? And they must respond. If they don't respond within 2 months, that's the end. The company is going to be removed by the registrar of business name. And if the registrar receives an answer that is no longer in business within 2 months, then that's also the death of the company. So I think that is like the major thing that I think I want to discuss on all this stuff. Every other thing I thought I would take enough time, but it seems I've been able to cover up within the time allowed. So that is what I want to say concerning winding up proceeding. So please, if you have any question, let's see if we can dissect it before